guys, welcome to this video. Today we are going to look at the case of Pett versus Greyhound Racing Association Limited. So we'll start by looking at the context of the case. So who are the participants of the case? One, we have Greyhound Racing Association. Secondly, we have Pett. Pett was a licensed dog trainer. This case took place in England between 1968 and 1969. So what are the issues, the key issues of the case? One of the key issues was that of legal representation in court and the right to legal representation. Let us proceed to look at the case facts and case details. So between April 1968 and February 1969, an unusually direct clash of judicial opinion arose between three of the lordships of the Court of Appeal and a single judge of the Queen's Bench Division in England, which has resulted in the variable content of the Audi alteram partem. That is a principle of natural justice which stresses the importance and the primacy of listening to the other side before condemning them. In fact, loosely translated, it simply means that no one should be condemned unheard. So Greyhound Racing Association was an organization which exercised substantial control over dog racing in Great Britain. The plaintiff was a licensed trainer, which entitled him to race his dogs on licensed racecourses. On September 6, 1967, one of his greyhounds, greyhound is a dog, a type of dog, entered for a race on such a course and was found to have been drugged, and the steward withdrew it from the case. So this dog was not following the rules of the game. Being drugged simply means it had what we called altered power, which means drugs could give it advantage over other dogs, unfair advantage. So an inquiry was ordered and the plaintiff was advised on the date, time and nature of the inquiry, and also the nature of the charges that he would have to meet. The notices arrived the day before the scheduled hearing. The plaintiff's solicitor immediately wrote requesting an adjournment so that he could be represented by counsel at the inquiry. The adjournment was grounded, but subsequently, before the hearing, the plaintiff was told he would not be allowed legal representation at the inquiry. He sought first a declaration that he was entitled to be represented at the inquiry, and secondly, an injunction restraining the association from holding the inquiry unless he was so represented. He then sought an interlocutory injunction, which was granted. To make case for interlocutory relief, the plaintiff would suffer irreparable injury and also needed to establish a prima facie case. A prima facie case simply means one in which pre-trial evidence is reviewed by a judge and determined sufficient to warrant the trial. Prima facie cases are typically civil cases where the burden of proof is on the plaintiff. So, on appeal, Lord Denning, Davis and Russell held that a sufficient prima facie case has been made out and the injunction must stand. Hence, the plaintiff was entitled to an oral hearing and had the right to appoint counsel or solicitor to appear for him. So we find that one of the major things in this case is stressing the importance of principles of natural justice, especially having representation or being represented legally. So however, one judge of the Queen's Division bench was of the opinion that the plaintiff was not entitled to legal representation at the inquiry, but 3 lords are of the opinion that legal representation is absolutely necessary. So we can always also see that 3 minds are better than one, and legal representation in fact is very important in any case, because in most cases you find that respondents may not be have knowledge or enough know-how of the going ins and outs or the details and the little nitty-gritties of the legal system, which legal representation really helps, especially in also protecting the rights of accused people. Thank you for watching this video. Like, share and subscribe.